This is DC Bar's Brief Encounters podcast. I'm Don Resnikoff, a member of DC Bar's Antitrust and Consumer community. Our topic today is state-level antitrust enforcement, and we'll be focusing on opportunities and challenges that face state antitrust enforcement. The DC AG's office is active in such enforcement, and it's a topic that's sort of close to my heart because I have past experience as an antitrust enforcer for DC, and it's something I feel is particularly important, and most especially because there are cases that locals can bring that aren't really of interest to anyone else, and I think that's an important function. Our guest today is Gwendolyn Cooley. She, until just recently, really, was chair of the Attorney General Antitrust Task Force. She was Wisconsin's Assistant Attorney General for Antitrust from 2005 through 2024. So she and I overlapped for a few years when I led the DC AG's antitrust efforts, which I did through 2008. These days, Gwendolyn consults on mergers, state attorney general relations, and antitrust policy through her law firm, Lindsay Cooley Law, LLC. Her office is in Madison, Wisconsin. And an interesting aside is that she's developing an artificial intelligence merger screening tool through her company called TimeIt. And that's really an interesting idea, but I guess it's not one we're going to go into today.
Indeed.
Gwendolyn has extensive experience litigating antitrust cases on behalf of the state of Wisconsin, including merger enforcement and conduct prosecutions. That experience and her work as chair of the Attorney General Antitrust Task Force put her in a position to share important insights on state-level antitrust enforcement. So, Gwendolyn, I thank you very much for being with us today, and we'll move on to questions.
Well, my pleasure, and I'm delighted to be here for the State Bar of DC, of which I am also a member. So this is fantastic.
Great. Let's start with an overview based on the National Attorneys General Antitrust Task Force. And I'll ask, how do state attorneys general fit into the U.S. antitrust enforcement system alongside DOJ and FTC? And in connection with that, I'll ask you to describe how state AGs and federal agencies coordinate in merger reviews or conduct cases.
Thank you for that, Don. And obviously, I know this is something you know very well as well. So I think it's important to start out with a disclaimer that I didn't used to give when I was the chair of the task force because I knew I was able to get in trouble if I said anything badly. So let me just say from the outset, I'm not speaking on behalf of the attorneys general or the DCAG in particular, but just let me give you an overview of what antitrust enforcement looks like. There's a three-legged stool of antitrust enforcement in this country. It starts with the Antitrust Division at the U.S. Department of Justice and also includes as an equal leg of that stool, the Federal Trade Commission, also in D.C., and the state attorneys general. The state attorneys general can enforce both their state, or in this case, district law, or often the federal law as well. And there's a surprising amount of unity amongst state attorneys general when they work together. Often they will work together through the National Association of Attorneys General, appropriately, which works together kind of hand in hand with the federal agencies. This was the case until recently, in the last few years, where some attorneys general have now moved out of the National Association of Attorneys General. So there's also some cooperation to a lesser extent through the Republican Attorney Generals Association and the Democratic Attorney Generals Association.
That's interesting. That split has occurred. Let me ask you this. When states do decide to bring their own antitrust cases instead of leaving matters to the federal agencies, why is that? And can you think of examples for us?
Sure. I mean, I think generally the reason why state attorneys general bring cases, and in this case, again, the district attorney general brings cases, is because those folks who are directly elected are really responsible to their constituents, right? They wear a lot of hats and they really are essentially on the pulse of what the folks who elected them are interested in. the DC AG's office is a great example because of the focus on housing. Obviously, in a district that is not particularly geographically large, right? Housing is very important, particularly rental housing, apartment buildings, things like that. So the DC AG's office was, I believe, the first to go after RealPage, which is an algorithmic pricing software that is alleged to have helped set rents, and the DC AG alleges was anti-competitive.
I think that's right. I think they were the first. And I think an interesting aspect of that, too, is that settlements were reached between the DCAG's office and local DC landlords, which is something that, of course, the DCAG has a stronger interest in than perhaps any other prosecutor. So that is an interesting example. When you talk about the state antitrust enforcement, there are some offices that are quite large. I think notably New York is a large office and California is a large office, and others are much smaller. DC's office is considerably smaller. I believe Wisconsin's is too. Is that right?
Well, DC and Wisconsin are not even in the same ballpark in terms of size.
Because Wisconsin's bigger, you mean?
Oh, you wish. DC surprisingly punches above its weight, but also has a large amount of antitrust enforcers right now. Now, I don't know how many were there when you were the chief, Don, but
Three.
Three. Okay, wow. Well, so Wisconsin never had three. We always had two or one. Currently, the DCAG's office has around 10 people in the antitrust shop doing antitrust, not just broadening that to consumer protection or charitable endeavors and all the other things that the Attorney General looks at. So there's a real focus in DC on making sure that antitrust laws are enforced properly. So I think that's part of the reason why DC, compared to its geographic size, compared to its population size, really punches above its weight, is because, having the bodies to do the cases really matters, but also the DCAG's office is able to attract the kind of intellectual leadership. I mean, not to butter you up, but case in point, right, Don, you came from the Antitrust Division over to the DCAG's office, right? And the same is still true now, right? There's experienced private practitioners, class attorneys, folks from the Antitrust Division or the FTC that then come over to the DCAG's office. So you've got that real depth of knowledge, which makes getting up to speed in cases much faster. In some smaller areas, it's harder to attract someone with antitrust experience to a position in small town America.
And I think, too, there's a point about efficiency of small groups. My boss at the time, a fellow named Bennett Rushkoff, who I think you know, he liked to say that if you have 1/10 the manpower or people power, you're not going to have 1/10 the efficiency. You're going to be able to work in a way more smoothly, in better communication, and get, relatively speaking, more done. And I think that's true.
Well, I mean, as a person who was essentially the chief cook and bottle washer of the Wisconsin Attorney General's office, Antitrust Division, including as chair of the task force, I found it very efficient to essentially have a monopoly on antitrust enforcement in the state of Wisconsin.
Yes.
So, yes, very efficient, though stressful.
Yes, both are true. Let's move on to some examples of successful federal-state cooperation in antitrust enforcement. And I think you're going to probably start us with the Google story.
Yeah. I mean, so there are a number of successful instances of cooperation, but let's just take Google search as one of the more recent ones. There is, as of this recording, and I don't know when this is coming out, as of this recording, no decision yet on remedies in Google search, but that was a case where DC joined with a big group of sister states who filed a complaint in parallel to the federal complaint. And so there was some significant coordination with the U.S. Department of Justice and the DC AG's office in terms of many things. They were active in both examining witnesses and preparing for trial, examining documents. So there is a really effective team. Part of that's through the federal state coordinator who helps manage the relationships with the states and districts across the country. And part of that is through the individual case leadership. And so in a case that was going to trial that had something like 3 petabytes of documents, you really need all hands on deck for something like that, especially when you're going up against, I don't remember how many it was, but I'm going to go with 6 law firms on the other side who had some resources behind them. So we'll see how that works.
Yes. Now, moving on to another topic, which is times when the state AGs disagree with the federal agencies. How does that work out? I know you have some examples ready for that.
Yes, well, we'll keep it high level and we'll keep it to antitrust. So the state AGs have disagreed with the federal agencies, and I think in a thoughtful way historically. So if you think about Kroger Albertson, and I think it's important to point out Kroger Albertson happened, in a time when you have a Democratic Attorney General of DC and a Democratic presidential administration. So it's not necessarily partisan to have a disagreement. So Kroger Albertson was a grocery store transaction that was proposed in the early 2020s. The exact date eludes me at this point. But so the initial concern was that the way the deal was being structured, essentially by making a payment to shareholders, would end up creating a financial profile for the company that would make it impossible for the companies to exist separately. So essentially, it would preempt the merger review. And so the DC AG's office actually, it's not that it necessarily disagreed with the agencies, but it went swiftly and it went alone and challenged that payout. Ultimately, it was unsuccessful. And then the DC AG's office obviously did cooperate in the larger Albertson Kroger case. But an example of the Albertson Kroger case, which ultimately was successfully challenged and then blocked. So that's an example where you have a disagreement about a specific thing, and then ultimately everybody moves forward in the same direction. There were 2 states that did disagree essentially with the timing, I think, more than anything. And those were Washington State and Colorado AG's office, who separately challenged the Kroger Albertson merger and were also successful. And Washington State was able to, actually, it worked out weirdly that they got the merger blocked on the same exact day that the federal court in the multi-state and FTC case blocked the merger. So that was very interesting. A case where there was a full-on disagreement about the remedy, and so ultimately a challenge, was the T-Mobile Sprint case that the DC AG's office was a part of. And that in particular, that's a case that I was a part of too. So I will just note that I'm only allowed to say so many things about it, but we challenged the acquisition of Sprint by T-Mobile, and the U.S. Department of Justice had filed a proposed consent decree that divested certain assets to Dish Network. We believed that that remedy was inadequate, and so the group of states, including DC, that filed to challenge it, the moral of the story was we ended up going to trial on that case, and we ultimately did not prevail because the court thought that the remedy of divesting the specific assets to Dish Network would be sufficient to create a 4th cell phone carrier. I mentioned this in particular today. I will note it is August 26th, and we just had news this morning that those assets are now being sold to AT&T. So it turns out we were right, that there was not, in fact, a 4th network. I will probably never get over being right, but maybe I'll stop rubbing it in at this point.
And I guess there's other history in the day when the states would step forward and want more aggressive remedies than the federal government wanted. I guess most famously Microsoft. I think that was a story.
Yes.
I'm going to ask you now about politics and resource differences among the states and how that shapes their role in antitrust enforcement. And we've said a little bit about that, but perhaps a little more.
Yeah. So I think certainly I've worked for Republicans and Democratic attorneys general. And I think that there are definitely differences in kind of what a specific attorney general's enforcement priorities look like. And essentially, the view is, right, they're elected by the people. And so if the people think that a specific enforcement priority is what they want, then that's what they should get. Now, the political differences shape kind of the direction, or really rather the approach to why they choose to do certain cases. But I think generally the politics there's a huge convergence of what Democratic and Republican attorneys general want. I mean, if you think again about the Google search case, that had 52 jurisdictions on the case. So that's all the states plus DC and one other territory. And I don't know if it was Puerto Rico or if it was Virgin Islands or Guam or Northern Mariana Islands.
I don't know either.
But right. So you've got a huge convergence politically there because even though, coming at it kind of from a different angle, but the resource differences, both in terms of bodies, assistant attorney general who are able to do these cases, but also in terms of the financial resources, right? Antitrust cases are hugely expensive. And certainly that's one of the biggest problems with them, but also one of the biggest, right? They're impactful to companies. So it's important that they be expensive and that they be thoroughly litigated. So some states obviously can pay more than others because they have more money, right? A California, a New York, a Texas, an Illinois, a Florida, those are big states. And so if they are involved in a multi-state, that can really change the direction. That said, I led a number of multi-states, and I'm from a state that doesn't have that many people with one person. So that was not the determinative factor. It was really, I think, much more an attorney general willing to commit the resources to litigating one of these cases that take a long time, typically outlast the tenure of any given attorney general, right? Just for perspective, one of the cases I led, the person who signed the complaint was Kamala Harris for the California AG's office. Right. And by the time it settled, she was the vice president. So, these cases take a long time.
Yes, they do. They do. Going back to the RealPage case, it had not occurred to me to think of a political dimension to that because it seemed to me that the DCAG was really just helping out DC tenants. Maybe there's a little spin to that Democrats like to help tenants, but it seemed pretty much on the same path as other states, even if DC was a bit of a pioneer in getting things started.
I think you're exactly right. I mean, there's a number of states interested in the RealPage case. Those states that use RealPage are pretty broad. I believe Tennessee is really active in it. They've got a Republican AG. So you definitely, because high rental rates would matter to both Republicans and Democrats, if the methodology for those high rates or the reasoning behind those high rates is alleged price fixing or an alleged wheel and spoke or hub and spoke conspiracy of antitrust price fixing, you're going to see AGs coming at that.
Now you mentioned that there's been a split in the state AGs so that there's now a Democratic group and a Republican group. And going forward with antitrust enforcement, what do you see in the future in general and with regard to that split in particular?
Well, so there's always been a Republican Attorney General's Association and a Democratic Attorney General's Association. It's just that there's a little bit more coordination amongst them and a little bit more unanimity. Although I will say, when you've got 56 jurisdictions and 4 are not participating with the National Association of Attorneys General, that still leaves you 52 jurisdictions that are cooperating through the National Association of Attorneys General. So you're still having that kind of continued cooperation and you're still having strong enforcement. The other thing I would say is just because they're not cooperating through the organization that is known as NAG, that doesn't mean that they are not, still cooperating. The state of Wisconsin was working with the state of Texas on the Google search case. We were on the US DOJ complaint for the Google search case. So there's still pretty extensive cooperation despite these kind of various groups, right? I think it's the difference between, what things look like politically at the AG level and the cooperation amongst staff. Obviously, Don, you and I worked together when you were in the DC AG's office and I was in the Wisconsin AG's office. And we worked with the folks in Texas and the folks in Florida and the folks in Tennessee and Ohio and Illinois and everywhere.
Another aspect is what happens when the federal enforcement becomes less enthusiastic or different. What do the state attorney generals do? And there's a complicated discussion, which I guess we're not going to have, about what's likely to happen with the current administration on federal administration on enforcement, because there's some indications that they're going to be quite strong, and it's a little unclear, but we won't go into that. But to the extent that in the past there has been a pulling back by federal authorities, there has been a fill-in by state AGs, I believe. And I guess your thoughts about what that would look like in the future. Would that be likely to happen?
I think that the question on everyone's mind is if the federal government drops the ball, will the states pick it up and run with it? I think the answer is that the states are already running with their own ball. I think they continue to bring the cases that they think are the most important to their citizens. Let's be very clear that the resources that the federal government has for antitrust enforcement can't be easily replaced by the 270 assistant attorneys general around the country. Federal enforcement is very important. It provides a different perspective, a national perspective on a case, right? It's important that state attorneys general have a local view of the transactions in mergers or the conduct in conduct cases. But the federal government provides a valuable national perspective that is not really interested in all the things that the attorneys general have to care about, right? If a plant closes in a state, that means that people are out of jobs, and that's bad, right?
Right.
And those are citizens of those states. Whereas the federal government has the opportunity to look at that and say, okay, well, they're closing a plant here, they're opening a plant there. We think actually it all comes out in the wash, and so that's okay with us. The state AGs still have the opportunity to challenge that, but it's three legs of the antitrust enforcement stool actually really work well together because they provide that complementarity of perspective.
Right. I think that's true. And going back to the Microsoft days, even though the point about lesser financial resources of the states, I think is very important. Those states can provide a push sometimes to the federal government that will cause it to go forward, maybe in a way it might not otherwise. So we can hope that will be the story in the future, if that, to the extent that becomes a problem. So I think this brings us, though, to the end of our chat for today. Is there anything you'd like to add before we finish up?
Well, I would just thank the DC Bar so much for putting this on. I am delighted to be able to chat with you. It's wonderful weather here in Wisconsin, so if you're ever trying to escape the DC heat, you should come visit.
Okay, thank you. Well, thank you very much for being here and contributing today. We appreciate it.
Thank you so much, Don.